Greetings again. This is the second part of this lecture in module number 7. This will be the last module for which you have a specific writing assignment, because in module 8, whereas I'll assign you readings in the area of religious freedom, your main focus will be on working toward your final term paper as your assignment that will be due at the end of August. Again, you need to turn in your proposed topic along with a brief abstract. That's a simple summary of about 150 words describing what you're going to be writing about. And then a list of several sources, both, say, books, scholarly books that you would use for research, and some articles that you would use, and maybe some from digital sources. All of these should be of scholarly quality, and that way I'll know you're on the right track. If you have any questions at all, you always email me at t.walsh@hji.edu. I'm always happy to hear from you. So I've got uh, PowerPoint I'm going to share for this second part in this. If I can make sure. Let's see here. Sorry for the delay. I think I am going to. Sorry for the delay. My apologies. I hope you can see this okay. Talk about a little bit about international law and topic of jurisdiction. I have a few slides on this. International law primarily seeks to maintain international order, just as we talked about criminal law and civil laws dealing with what we might call domestic or within a sovereign territory, within a country. This pertaining to international law operates similarly, but seeking to provide that order on an international level by compartmentalizing territory and individuals into sovereign states. One of the defining aspects of sovereignty is the exclusive right of each state to govern its own internal affairs. That's part of the definition of national sovereignty. Jurisdiction relates to the authority of a state to exert its influence and power in practice, make, apply, and enforce its rule. So there are 5 principles of jurisdiction. We know known as the territorial principle, the nationality principle, passive personality principle, protective principle, and the universality principle. In the territorial principle, a state may exercise jurisdiction over the acts of anyone, nationals or aliens, committed within its territory. In other words, it has jurisdiction. Territory includes the territorial sea and airspace of a given sovereign country. And flag ships that sail under the flag of a particular nation have also enjoyed this territorial principle. Exceptions, like here in New York, diplomats that move to work at the UN, they have diplomatic immunity, or foreign military personnel would have immunity. The second principle is the nationality principle, that a state may exercise jurisdiction over any acts perpetrated against its own nationals, no matter where they are committed in the world. So if someone is harmed, a U.S. citizen is harmed in the Philippines, then the U.S. still has capacity to exercise jurisdiction. And a quote here, until the advent of international human rights law, the manner in which a state treated its own citizens was of no interest to international law. An act that may not be illegal in the host state, such as bribery, which is unlawful in the United States, or evasion of U.S. tax or antitrust laws that a nation would still have jurisdiction. Then there's something called the passive personality principle. A state may claim jurisdiction over any person who has injured one of its nationals, one of its citizens anywhere in the world. A potential offender may not know what laws he or she may be subject to, and this ought to be limited to serious offenses that are prescribed in all states, such as terrorism. So if a U.S. citizen is injured in another state, still the U.S. can claim jurisdiction to bring the perpetrator to justice. Then the protective principle allows a state to claim jurisdiction over the acts of any persons committed anywhere if such acts threaten the state's national security or core interests. For example, if a Hungarian is counterfeiting U.S. currency in Venezuela, the U.S. could exercise jurisdiction because it's a threat to the U.S. national security or its core interests, such as the value of its currency. Or an example of a foreigner lying to the U.S. consulate officials when applying for a U.S. entry visa. The U.S. can again claim jurisdiction or authority according to this protective principle. And another principle is the universality principle. Universal jurisdiction applies to crimes against the community of nations. A U.S. court can try a Somali pirate for seizing a French vessel on the high seas on grounds of universal principle. And here are a few YouTube sites on this. Abdulwale Muse, indicted in the Southern District of New York for 10 counts of piracy, conspiracy to seize a ship and take hostages, firearms. Piracy requires a mandatory life sentence without parole. Pleaded guilty to hijacking, kidnapping, and hostage taking, and was sentenced to 33 years and 9 months in prison. This is an example of the application, in this case by the U.S., against the Somali pirate Abdulwale Muse. So these are just an example of the jurisdiction as it applies to international law. And I'm going to conclude this short series of PowerPoint, and the PowerPoint is available in the module as well for you to review. And now I'm going to look at one final screen share and go through this and hope it comes up okay on the screen. Now, again, these are categories related to the War Crimes Tribunal at Nuremberg. What are war crimes? These are crimes against peace. Quote, planning, preparation, initiation, or waging of a war of aggression or a war in violation of international treaties. These are crimes against peace. There's also crimes against humanity, which also involves membership in a criminal group or organization, criminal conspiracy. Crimes against humanity, murder, extermination, enslavement, deportation, other inhumane acts committed against civilian populations, whether or not in violation of the domestic law of the country where perpetuated. This is written into the Nuremberg Charter. Contemporary international documents state that crimes against humanity are specific acts of violence directed toward the persecution of a group of persons. Definition of genocide, going back to the Genocide Treaty of 1948, Article 2 of the Genocide Treaty. In the present convention, genocide means any of the following acts committed with intent to destroy in whole or in part a national, ethnical, racial, or religious group, such as killing members of the group, causing serious bodily or mental harm to members of the group, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part, D, imposing measures intended to prevent births within the group, E, forcibly transferring children of the group to another group. These fall, according to the Genocide Treaty. Genocide consists of, as described by Article 2, these characteristics. So the Tokyo and Nuremberg military trials following World War II, the Nuremberg Charter, crimes against humanity, and waging aggressive war were brought against the Nazis in Germany. Such crimes permit an exercise of universal jurisdiction, not just domestic. In other words, this wasn't just an issue for the German courts. This was international law or universal jurisdiction applied because of the nature of crimes against humanity or waging aggressive war, including genocide. And in this case, such cases, any state may exercise its jurisdiction. All states have a duty to prosecute or extradite, and all states must assist in securing evidence. So these crimes against humanity, some of you recall when we looked at the UN, we talked about responsibility to protect, R2P, responsibility to protect. When there was a genocide going on in Rwanda, Burundi, there was great regret that the UN and other nations, the African, didn't intervene to prevent these horrific acts of criminal intent and execution. So the Nuremberg laid down these principles in its charter that all states must respond and put an end to these crimes against humanity, and that they have jurisdiction and a duty to prosecute or extradite. No immunity for heads of state. There was a person couldn't say, I'm immune to the genocide that I ordered to be carried out because I'm a head of state. Also, individuals and states may be prosecuted when it is indeed the central government that is the perpetrator. So international criminal jurisdiction, we talked a little bit about that earlier. Extraterritorial, the principle that a nation can project its jurisdiction beyond its national borders. So in these cases of crimes against humanity, there is this extraterritoriality capacity or jurisdiction. It must be based on a treaty or a convention or on one of the following principles that we looked at earlier: territoriality, nationality, the protective principle, the passive personality principle, and universality. So there was a path from these trials, the Nuremberg trials, to the formation of the International Criminal Court. Initially, the Nuremberg and Tokyo trials after World War II, that is, the war crimes committed by the Nazis, Germany on one hand, and Imperial Japan on the other hand, they were ad hoc. There was specific processes set up to try the perpetrators of these crimes against humanity. And there were also international conventions set up through the UN to prevent mass killings. And at this time, the appointment of ad hoc, again, for these specific purposes, tribunals in the 1990s by the Security Council. So these are steps that take us from the time of Nuremberg following World War II to the establishment eventually of the International Criminal Court. Continuing this on this process or these steps toward the ICC, there was also the International Criminal Tribunal for the former Yugoslavia, ICTY, the International Criminal Tribunal for Rwanda, ICTR, which I mentioned previously, and the Special Court for Sierra Leone, SCLC, in 2002, Special Tribunal for Lebanon, STL, 2007, the Extraordinary Chambers for Cambodia in 2003, and here's a link. And then the International Court, the Statute of Rome in 1998, ratified by 122 countries. Neither the US nor China have ratified the ICC. Many nations fear that they will be targeted, or not many, at least some of the great powers, that they will be targeted unfairly due to their high profile. So the subject matter of jurisdiction applies for the ICC to genocide, crimes of genocide, crimes against humanity, war crimes, crimes of aggression. Concerning crimes of aggression, this Rome statute states that the crime of aggression means the planning, preparation, initiation, execution by a person in a position effectively to exercise control over or to direct the political or military action of a state of an act of aggression, which by its character, gravity, and scale constitutes a manifest violation of the Charter of the United Nations. The act of aggression means, quote, the use of armed force by a state against the sovereignty, territorial integrity, or political independence of another state, or in any other manner inconsistent with the Charter of the United Nations. These acts can include, among others, invasion, military occupation, and annexation by the use of force, blockade by the ports or coasts. So ongoing investigations by the IC are highlighted in this map. And you see a number in Africa, and Africa is some way complained that they are being targeted by the ICC. So not everyone's completely in love with the ICC, but it is part of the development toward international law and addressing crimes against humanity as a key part of international law. And this kind of got the ball rolling and building momentum after World War II, just like we had the United Nations formed and we had the Universal Declaration of Human Rights. We also had, as an outgrowth, this move toward the establishment of the International Criminal Court. So that concludes my lectures for this module. Keep up your good work. You're good students. I'm impressed. But just keep it up. One or two of you are a little bit behind in an assignment here or there. Please catch up on that and give also your full attention, not only to this module 7, but looking ahead to your final term paper. I'm always available, t.walsh@hji.edu. Great to have you here at HJI. All the very best. Thank you.